Thank you very much, not only for the floor, but also for organizing the conference and for the opportunity to meet you in person, all members of our research group, because it is a pleasure to discuss details of our research in person. And especially thank you for the Central European Professors Network, because to tell the truth, me personally, my research focuses on international human rights law, international humanitarian law, international criminal law, and before this year, I haven't read as many decisions of the Constitutional Court of the Slovak Republic as this year. It was a big challenge and actually a gift, so thank you very much for my academic improvement as for the national legal framework. As for today's conference, I've chosen one particular decision, because having read the decisions of the Constitutional Court of the Slovak Republic, I've come to a very strange opinion or hypothesis I'd like to prove today. I'd like to show it to you. I've chosen one decision from 2012. At the first glance, when you see the decision, it is perfectly supported with all areas of argumentation. I've chosen a decision that, as for methodology, it has included all those arguments that we have researched for in our research. So it means a historical, comparative, systemic, contextual, even non-legal arguments, of course, as for the Slovak Constitutional Court, as many scholarly works as possible, and even general legal principles and own case law. But since to tell the truth, I know the case law of the European Court of Human Rights better than the case law of the Slovak Constitutional Court, I was surprised by the way how the Constitutional Court of the Slovak Republic has used the case law of the European Court of Human Rights. What actually I mean? Reading the cases, the decisions of the Slovak Constitutional Court, I've come to a conclusion that external systemic argumentation and case law is used to support the decision of the Constitutional Court. That's understandable. But the relevant case law is used in a different way as it was used by the court. As you have already mentioned in your presentation, I thought that the Slovak Constitutional Court is unique, but maybe it is not. First, I'll present the facts of the case and then why I have found the argumentation not necessary to get to a conclusion. I'm not going to criticize the finding itself, but the methodological approach of the Constitutional Court of the Slovak Republic. So as for the facts, there was, I'm not sure whether you can read it because the letters are so little, but the case was initiated by a district court that had issued a warrant of execution against the Slovak Republic, namely Ministry of Justice. But that warrant of execution could be paid only partially because of the execution immunity of the states. That's, I think, pretty usual for all the states we come from. And since the district court didn't like the result of the whole procedure, it has applied to the Constitutional Court and asked for the compliance of the relevant legal norms with the Slovak Constitution and international treaties, especially European Convention on Human Rights and Fundamental Freedoms, because according to the Slovak Constitution, some international treaties, under certain conditions, have precedence over law. Not the Constitution, but the law. And what actually the Constitutional Court did, it analyzed the relevant legal norms in relation to property rights and also right to a fair trial, and especially in relation to non-discrimination. But in relation to external systemic and comparative arguments, it was rather selective. The year of 2012 was a year when, for example, International Court of Justice adopted a famous decision in relation to state immunity, but the court didn't mention the case, although it was initiated by the Greek approach, and the Greek Gistomo case was mentioned in the decision of the Constitutional Court. One of the factors that influenced our choice of decisions that we analyzed was the fact that the particular case law of the European Court of Human Rights was included in the decision, and it was also the case in this decision. Maybe you know the decision in the Alazzani case that concerned the right to a fair trial. It means whether in relations among states certain petitions by individuals are accepted, admissible. And that was the area where the Slovak Constitutional Court, after all that systematical, grammatical, and contextual argumentation, came to the case law of the European Court of Human Rights and focused on dissenting opinions rather than on the decision, and declared that the decision was adopted by a majority of 8-7, so it was not so decisive, and pointed out what the immunity is, that it has been an institute that was created by the principle, or influenced by the principle of par in parem non habet imperium, and that in fact in legal relations among states it is a bar to proceedings. But the Slovak Constitutional Court decided to take another approach. The Court of the Slovak Republic decided to apply the proportionality principle, showing that the par in parem principle would be too formalistic approach, and that it would not support the idea of human rights protection. And that's why, despite admitting that the Institute of Immunities has got procedural character, according to the Slovak Constitutional Court, it would be a pure formalistic approach, and then, methodologically speaking, they decided to admit the institute, but take another way, the test of proportionality. So the following, after explaining the whole concept of state immunities, they've decided to ignore it, and they said that the test of proportionality, all three phases have to be analyzed, and they've gone through the sustainability and necessity and the proportionality stricto sensu, and they've come to a conclusion that since the relationship among the state and an individuals is different from if compared to the relationship among states and the principle par in parem non habet imperium, the principle does not have to be taken into account. Now I've just put it a little bit schematically together. So what I'd like to point out is that there are some cases decided by the Slovak Constitutional Court. Me, myself, I'm quite often a critic that our Constitutional Court does not take into account the case law of the European Court of Human Rights. But there are cases when the case law of the European Court of Human Rights is taken by methodologically wrong way, either to support the decision, the finding, or just to point out that it is not relevant and that the Slovak Constitutional Court understands the concept much better. It does have influence also on the decisions of other national judicial bodies, for example, our Supreme Court, because there are other cases when the principle of state immunity, despite having the same term of immunity, if you compare state immunity and immunity of state officials or immunity of state representatives, these concepts have different content. And even our supreme judicial bodies, having all their legal advisors, do not distinguish among different concepts of international law. And that's something, methodologically speaking, that has really surprised me. And that's what I wanted to point out during my presentation. Having focused on the methodology of the decisions of the Slovak Constitutional Court, that might have been the outcome that was not planned by the project, but it has helped me and also my colleagues a lot to work on later. Thank you very much for your today's attention, and if you have any questions or comments, I'd be happy to hear them. Thank you.